Good morning, everyone, and welcome to the Fair Housing Center of West Michigan's Fair Housing 101 training for rental professionals. I know we still have people logging on to join us. We had a tremendous response to this training, so we wanted to open up a little early to allow folks time to get into the Zoom. We are really thankful to MISTA, the Michigan State Housing Development Authority, for providing this opportunity, a grant for us to offer this type of training to all of you. So thank you so much for logging on to join us. We have a little bit of housekeeping as people continue to log on. We've had a couple questions about how do we register that we were here today. And so I really want to encourage you to pay attention right now if you can. We need each individual, even if you're attending as a group, we need each individual attending today to separately complete an evaluation using a survey link that we'll provide at the end of the class. This is how we're tracking attendance, and this is how you can get on the list to get a certificate. So we ask that you complete the evaluation no later than the end of the day tomorrow. So again, we will provide that link towards the end of the class today and make sure that gets out to all of you. All of you are muted and your cameras are automatically set to off. So if you do have questions, you can use the Q&A to submit questions about the training that you'd like answered. It's helpful for us if you do use the Q&A for those types of questions. You can use the chat to message us to request any assistance, or if you didn't get the handouts that we sent yesterday, please let us know through the chat. We are recording this session and we'll make it available on our website, and we will send that out once that is posted and available as well. We do have a series of trainings that we're doing. So this is the first of the winter series. We will have a 101 introductory class, a 201, and a 301. So you can find more information about that on our website, and we encourage you to take all of them. If you can't join us, though, we're going to have a second round, a summer series, and those dates and registrations are also available on our website, and that starts in June. So we'll take a break about halfway through this morning. We have a lot of great information to share with you. If you're following along using the slides, you have most of the slides, but there are some that we deleted because we either don't have permission to share or they were bad examples of what not to do. So we don't want to put those out and have anybody get confused about that. So you'll have a lot of great information. Any of the links that are blue in the handout of the PowerPoint slides should open the source document for you. So you have lots of information not only attached to that email, but within the PowerPoint handout. If you are logging on individually, you'll all see that the evaluation should open automatically in your browser after the webinar ends. But again, we do need each individual attending to complete the evaluation online separately. So even if you're watching as a group, make sure you share the link with each other, make sure that you each individually get on and complete the evaluation. This is how you can get a certificate from us. And we ask that you do that no later than the end of the day tomorrow. We also ask that you give us time to get the certificates out. We had about 350 registrations for this training, and we're a very small department, so it does take us several weeks at a minimum to get certificates out to everybody. We appreciate that you're here today and are anxious to document your attendance. It's one of our best practices that we recommend. So we will definitely follow up on that. And again, I want to thank MISTA for sponsoring this whole training series. We will be doing a few more deep dives in addition to the 2 rounds of these sessions. So we have lots of great content to share with you this year, thanks to MISTA. So I want to welcome you on behalf of our team. I'm Liz Keegan. I'm the Director of Education and Outreach. I have Brianna Miranda and Lindsay Owens joining me today. They are Education and Outreach Coordinators, and they will be presenting at different times. And also, we're just kind of managing all the elements of the webinar. Here's our contact information. I highly recommend you visit our website. We have a tremendous archive of searchable materials and lots of good information on there. You can also follow us on Facebook, where we post information about cases, events, facts, interesting things on fair housing. So we're putting out a lot of good information. So this morning, we're going to talk about the Fair Housing Center and our work. We'll spend a lot of time thinking and looking at what is housing discrimination, better understanding what the laws are, and then a good chunk of time talking about the different protected classes to help people understand who is protected, what examples of violations there might be, what best practices we can share with you. We'll talk about how the laws are applied, very quickly talk about testing and investigations, and the Equal Housing Opportunity logo. So as I mentioned, please use the Q&A feature to submit questions about the training content. There is no test at the end. We will be offering some poll questions to just kind of hear from you a little bit, but there is no grading and no kind of pass fail of this training. That's not what we do. So as I mentioned, we're going to start with a few polls, and one of the things that's helpful for us to hear about is your level of fair housing experience. So if you are a group, you'll have to kind of complete these together. We'll give a couple, maybe a minute to hear from all of you. It's helpful for us to know how experienced everyone is, so that we can kind of tailor our questions and examples. All of the polls are anonymous. This is, as I mentioned, not a graded or tested process. So I'll give another 20 seconds or so. A lot of fast responses here. That's helpful. And we have, I think, so far a really diverse spectrum of levels of experience, which is always nice. Okay, I'm going to go ahead and end the poll and share our results with you all. So we have more experienced folks on the call than not, so that's great. We do have new information to share with you, and appreciate you taking the time to join us again. And a good percentage are also just getting started, so welcome. Now we are going to get started thinking about the protected classes. So here is a question, and since this is a more experienced group, we're going to hint that we're looking for who are the federally protected classes on this list. So hopefully you can check all of the ones that you think are protected everywhere in the country under federal fair housing laws, under the Federal Fair Housing Act. We really emphasize getting to know the protected classes, so this will help us start thinking who they are. And for those of you who are new, we'll be looking at federal, state, and local protections today. And another 30 seconds here. All right, let's stop and share. So we can tell this is an experienced group. I will look at who is protected class under the federal fair housing laws. Those of you who said race, religion, and sex are correct. National origin is also protected, as are disability, adults with dependent children, and color, meaning skin color. So those are the federally protected classes. Smokers, that is a group that is not protected. So a property can decide whether they allow smoking or if they have a smoking ban. That is not protected. Credit history is also not protected, but it is something we're going to be talking about. as there's some new HUD guidance talking about kind of the impact of screening based on credit history, but it is not a protected class, and convicted felons are not protected as a protection at the federal level. We are seeing some local communities adding that protection, and we will talk more about that as well. All right, and now we're going to have a quick series of true and false to help us start thinking about applying fair housing laws. Give another 30 seconds here. And once again, these are not being graded, or we don't have a pass-fail system for these. These are just to help us get thinking about applying fair housing laws. And if you're just joining us, we encourage you to watch for the evaluation link. That's how we will be taking attendance this morning. So each person individually must fill out our evaluation. It's a SurveyMonkey link we'll provide at the end of the class. So that will be something to keep an eye out for, and that's how we're going to track attendance today. That's been a very common question of how do we sign up and let you know we were here? And you each need to fill out that survey by the end of the day tomorrow at the very latest. Okay, I'm going to go ahead and close the poll. We had a diversity of responses, which is always kind of interesting to see, but large agreement on our first question. Anyone can file a fair housing complaint, residents, visitors, property managers, etc. 97% said true, and you are correct. Anyone has the ability to start the housing discrimination process through different mechanisms. So we train from a really conservative standpoint to help you be prepared to hopefully eliminate any possibilities of fair housing complaints, but also be prepared to respond to them, because anyone can file. So the process starts, and it's on the person who's been named in the complaint to tell your side of the story, what happened from your perspective. So good to know that on the front end. Number two, maintenance staff cannot be held responsible for stating preferences for certain types of tenants. False. 83% of you said false, and that is accurate. Anybody representing the property, regardless of the role that they play, if they are turning people away based on a protected class, that is a fair housing violation. And our third one, property manager has the right to inquire about whether opposite sex children under the age of 18 will have separate bedrooms. 70% said false, and that is correct. We really encourage not collecting information about who sleeps where, how people are related, getting into kind of the weeds or details of those relationships between family members. It really doesn't matter. It's not our business. What we simply need to know is how many people want to live together and if they can fit in that space under reasonable occupancy standards. So another best practice there. Okay, great job on those. Thank you for playing along. I'm going to turn it over to Lindsay to talk a little bit about fair housing and some of the trends that we're seeing before we dive into the rest of our content.
Hi, everyone. Thank you, Liz. I'm going to provide a brief introduction to Fair Housing, our organization, and the work we do. So to start, what is fair housing? That's probably the reason you all are on today for our fair housing training. So fair housing is the right of individuals to obtain housing of their choice, free from discrimination based on protected classes under federal, state, and local fair housing laws. Fair housing protects against discrimination in housing transactions, including rentals, sales, lending, insurance, zoning. There's a whole list of them. Our organization, the Fair Housing Center of West Michigan, or FHCWM, was founded in 1980 as a private nonprofit fair housing organization out of a combined grassroots effort to desegregate schools and integrate neighborhoods. The Fair Housing Center of West Michigan seeks to prevent and eliminate practices of illegal housing discrimination and ensure equal housing opportunity. We do want to clarify that all the materials and education that we're providing today is for educational purposes only. We are not attorneys, and so this is not legal advice. So if you are seeking legal advice, please consult an attorney. Sometimes there's a bit of confusion about the work that our organization does. So we want to start by telling you what we don't do, just to clarify. So our organization does not address landlord or tenant law matters. We do not teach home buyers classes. We don't teach credit counseling. We don't work strictly on affordable housing issues, although sometimes affordable housing issues come up in the work that we do, but it's not something we strictly work in. We do not handle building code and maintenance issues, and we do not do foreclosure prevention. Here's some of the things that we do. Our organization provides fair housing education to a variety of different groups of people. We provide fair housing education to rental and housing industry members, to home seekers, to the general public, and advocates. We want to stress that without the cooperation of people in the housing industry, we wouldn't be able to accomplish our mission. And we often rely on self-policing and commitment to fair housing from people in the industry. We also provide fair housing enforcement services. Enforcement involves complaint taking, investigation, analyzing information, and if warranted, working towards resolution. Ideally, enforcement wouldn't be necessary, but sometimes the laws and the education that we do are not always enough. So enforcement is really necessary to ensure that equal housing opportunity for all is occurring in our community. Here's some of the ways that we bring in funding for the work that we do. So we have contracts with city, county, state, and federal governments to provide fair housing services like education, enforcement, investigation. We also have an annual membership drive that you all could participate in, that we run every year to bring in a bit of funding. We also have an annual fair housing workshop series that we have in April. We also do consulting and training, and we have special projects and sometimes work with different senior millages in our service area. So there are several different organizations across the state that offer fair housing services, including the Fair Housing Center of Metropolitan Detroit, Fair Housing Center of Southeast and Mid-Michigan, Fair Housing Center of Southwest Michigan, and us, the Fair Housing Center of West Michigan. And we are independent from each other, but we do work collaboratively at times. Here is a map of the different coverage of fair housing organizations across the state. Our coverage is in kind of a turquoise color, is how I describe it. We cover 38 counties, including the entire Upper Peninsula. Recently, the National Fair Housing Alliance, which is kind of like a federal fair housing advocacy organization, put out a report on fair housing trends in 2023, and they noted that 83% of fair housing complaints took place in the rental process in 2023. So this is kind of underscoring that our education to the rental housing industry and rental housing professionals is incredibly important. As an organization, last year we had a total of 140 cases. The majority of these cases were based on disability status, followed by race and color and familial status. But you can kind of look at this graph and see what some of the different protected classes and cases are that we had last year. And then finally, our cases by kind of housing transaction. Again, our education to the housing industry is incredibly important, specifically the rental housing industry. Last year, rentals accounted for 52% of case transactions. Additionally, reasonable accommodations accounted for 33%. of housing transactions. So again, the education that we're doing today is really, really important, and we want to make sure you all have the information to know what to do in different situations and how to uphold fair housing laws in the places that you cover.
Thank you, Lindsay. And again, we're really thankful to Mishta. They are one of our large contractors that has been able to help us expand our service area and also offer this training. So we're going to turn it back over to our audience, to all of you today for a quick poll. Quick true and false here for you. A newspaper or online ad that describes the type of person a landlord or property manager wants to rent to is acceptable under fair housing laws. True or false? What do you think? Can you talk about the perfect tenant or the perfect resident in an advertisement, whether it's in print or online? We'll give another maybe 15 seconds here. This has been a pretty quick response. Again, helps us understand we've definitely got an experienced group online today, which is so great. It's really great that you all are seeking this training out. We're really thankful for the industry. As Lindsay said, we rely on all of you to proactively comply with fair housing or contact us with issues where we can help you figure out how to comply. Okay, I'm going to go ahead and end our poll and share the results. So there was big agreement here, largely 91% said this is false. And I would agree with that. You do not want to describe the type of person you want to rent to, because if we think about some of the protected classes that we've already looked at and talked about this morning, it's pretty easy to trip up. For example, as soon as you state a preference for a gender, for example, you eliminate about half of the market, and it's a violation of fair housing laws to have that type of preference. So the best practice that we recommend is focus on describing the property. If you're related to a program that has offers housing, you want to focus on the program elements and not the people. So describe the property, not the people. And we'll kind of get into why that is and why that matters. These are some examples where preferences are stated. As you kind of review the statements, you can see that we've got some implications for an elderly couple or only one person, a couple or one person in an awesome spot downtown. Looking for someone who's hardworking implies that you need to be employed. That has disability protection implications. Ideal for two singles or a married couple. You can see a lot of these references are households that do not include children under the age of 18, which is a protected class as well. So these short, succinct phrases might seem ideal for marketing purposes, but under fair housing law, they are violations. And we see people get very specific or kind of create profiles of who the perfect tenant would be. For example, one or two people or a couple with a max of two children, that sort of profile is not acceptable, where you're kind of determining who can live somewhere and putting that out there. This last bullet point is actually a case that was filed with HUD. So we'll have an update on that for you, but this was a housing provider requesting a brief description from every applicant, including their race and age, and also requesting a recent picture, which is definitely not a best practice. They further have a criminal history ban, which we will also talk about as not in good compliance with fair housing guidance right now. We also tend to see a lot of photos of human models. So examples here. And we see a lot of what's available that is not trademarked or is copyright free tends to be pictures like this. So finding photos that are low cost or no cost, that have a diversity across race and ethnicity, across physical ability, is very challenging. So one method to be in good compliance with fair housing is to avoid pictures like this and use pictures of the property and the amenities instead. To be effective in advertising, if you are going to use human models, you need to use a diversity of images that represent all of the protected classes and are representative of the metropolitan area where the housing is. So it takes more work, and it's something that we want people to be aware of. So you, again, really want to focus on describing the property, and that includes in your communications as well. Something that the fair housing laws cover under advertising is just conversation and communication about housing. For those of you who have any federal or state funds coming into the housing programs or a loan that helped develop the housing, you have to have an an affirmatively fair housing marketing plan on the record. So you have to create and implement affirmative marketing plans that reach all of the protected classes, especially those who are least likely to apply. It's a marketing strategy looking at attracting buyers and renters of all majority and minority groups, regardless of the protected classes, and really making sure that people have access to the information about these opportunities for housing. I think the housing market has slowed a little bit compared to how intense it has been. But people are still contacting us all the time looking for housing. So these affirmative fair housing marketing plans are really important. We do have a fact sheet linked here. We've got HUD's guidance linked here. And recently we partnered with the Fair Housing Center of Metro Detroit to do a joint training. So you've got a video link to that training right here on the slide in your PowerPoint handout. So lots of resources. So again, if you're federal or state funded, insured, or assisted by those dollars, then you have to have this marketing plan in place. So make sure you check that you know where your funding is coming from, find out if this applies to you, and make sure you have this plan in place. And make sure it's updated with the latest fair housing law and guidance. Discrimination based on the classes protected under federal, state, and local law, it's illegal. So that's why it matters. And also, we want to help you prevent housing discrimination because we really can't undo the harm of when housing discrimination occurs. We can't erase what happens for folks. So it also makes a housing search much harder and can really limit people's opportunities, not only to the housing, but to schools, jobs, transportation, and all the things that come connected to our housing based on our modern world. So let me get rid of this here. So our liability questions. Sorry, I'm not sure why that's continuing to pop up there. Intent to discriminate is not required. So whether somebody meant to break the law or not, it is not a requirement. So you need to know the laws in order to proactively comply. And that's why you're here today. And that's why we tell you sign in, make sure you get your certificate, document attendance at trainings, because it's important to understand your obligations on the front end. Fair housing in the First Amendment, fair housing laws were written very carefully. We all have biases, we all have filters, but we cannot allow those to interfere with access to housing if we are a commercial housing provider. If we're offering housing in exchange for rent, we are covered under fair housing, and so we cannot let our biases trump these laws. Liability is also not dependent on supervisor screening. So this is the benefit of everybody not being able to, or the benefit of everybody understanding fair housing and keeping in good compliance. And of course, ignorance is no defense. So the courts have held over and over again that people cannot say they didn't know better as an excuse. It's not a valid defense against a fair housing complaint. So. Getting into the laws, we have a long history of attempting to address fair housing laws. The Civil Rights Act of 1866 began with race and real property as kind of establishing the right of all persons in the U.S. to have equal rights to white persons at the time. That was followed up also as part of Reconstruction that all persons have the full and equal benefit of all laws as enjoyed by white citizens. So that is kind of the foundation, and we can still utilize those laws today. So discrimination on the basis of race is absolutely prohibited. This is something that has been well established, and you can see how old these laws are. So that's important to be aware of. We have some exemptions, and so the exemptions are also going to be exempt from the ability to discriminate on the basis of race. So you can never discriminate on the basis of race because of those early fair housing laws. I'm going to pop over, hopefully successfully, to share a great video that will kind of fill you in on the rest of the history of the Fair Housing Act and all of the protections as they unfolded over time.
Few in the nation believe that fair housing would in our time become the unchallenged law of this land. And indeed, this bill has had a long and stormy trip.
Well, I don't know what will happen now. We've got some difficult days ahead. Like anybody, I would like to live a long life. Longevity has its place. But I'm not concerned about that now. And I've looked over and I've seen the promised land. I may not get there with you, but I want you to know tonight that we as a people will get to the promised land. So I'm happy tonight. I'm not worried about anything. I'm not fearing any man.
Ladies and gentlemen, Martin Luther King was shot and was killed tonight in Memphis.
The death of the prophet of nonviolence set off the worst outbreak of arson, looting, and criminal activity in the nation's history. Washington's ghettos burned within a few blocks of the nation's capital.
The life of a man who symbolized the freedom and faith of America has been taken. And no words of mine can fill the void of the eloquent voice that has been stilled. But this I do believe deeply. The dream of Dr. Martin Luther King Jr. has not died with him.
President Johnson was willing to speak up and say, we have to pass a fair housing bill.
Hello, Mr. President? Yes, Dick. We're in trouble. We need some help. Yes? I'm afraid of that.
Federal troops, for the first time since the Civil War, took up positions to guard government buildings.
Nothing's probably touchier than your own neighborhood and your own home or your own apartment. The administration, which supported the bill, said this has no chance. The other stuff is okay, but this will kill any politician that touches it.
Well, I just could not live beside them. I don't feel that they should be oppressed. But I moved here because it was a white community.
I have 2 daughters and 2 sons. And if there's too many colored people around here, I definitely will get out.
I think that, well, the property values will immediately go down if they're allowed to move in here in any number.
It seems as though our country is pulling apart into separate societies, where whites have jobs and Negroes have unemployment, where the middle class lives in suburbs and the poor are left in the ghettos, where one group of Americans looks upon another group of Americans with growing mistrust and even dread.
Then the bill went over into the House Rules Committee, and under the chairmanship of the famous Judge Smith, a right-wing segregationist from Virginia, he wouldn't hold hearings on it. He would take the bill home so nobody could act on it. And we were running out of time.
Thousands flowed through the rainy streets of Memphis this day, finishing a march that Dr. King planned to lead in support of striking garbage workers.
How many men must die before we can really have a free and true and peaceful society?
For your presence, Lord. And I know you'll reach out and take mine. You take our hand.
The death of Martin Luther King is a tragic thing, but no legislation should be passed as a memorial to anyone.
In spite of the riots, I am going to support this legislation with all the vigor that I possess.
The laws that we pass up here are for all time. The Martin Luther Kings come and go.
The public reaction to this horror gave the sensible members of the committee a compelling argument that the House Rules Committee had to report that bill out. And I think that's how we got our bill. They just didn't dare bottle it up any longer.
And I have a dream that one day Negroes will be able to buy a house anywhere that their money will carry them.
At long last this afternoon, fair housing for all is now a part of the American way of life. Democracy's work is being done, and the bell of freedom rings out a little louder. We have come some of the way, not near all of it.
Fight still goes on because we unfortunately have the laws, but we don't have the enforcement. That we have changed, but we still have the same kinds of discrimination.
The U.S. Commission on Civil Rights said today that efforts by federal agencies to end housing discrimination have been generally superficial or incomplete.
President Carter has ordered federal agencies to use all means possible to strengthen fair housing programs.
For the first time, people with disabilities and families with children will be protected from housing discrimination.
President Reagan signed legislation today designed to toughen up the nation's fair housing laws.
Why did you take part in this demonstration today? Just because there was a huge crowd, or did you have any personal reason?
Well, I took part in this march today because of Martin Luther King and what he stood for, because this march is what he died for.
You know what he stood for?
Yes. He stood for nonviolence and peace for all men of all kinds. And I think if he died for it, I could carry out what he started.
So hopefully that was kind of an insightful look at some of the history and the layers that have since been added onto the Fair Housing Act after 1968 and the Civil Rights Movement, which most people are more familiar with. This law did give us our first four protected classes: race, color, meaning skin color; religion, and national origin, meaning where someone is from, their ancestry, ethnicity, etc. It also gave us this section of the law, this Section 804, which is what I was beginning to talk about with any communication, any advertisement that states any sort of preference, limit, or discriminates based on any of the now longer list of protected classes is a violation. It's unlawful to state any sort of preference or be a part of it being made, printed, or published. So that opens up really the chain of liability much broader to who can be held responsible for discriminatory messaging and ads. This is an example of an ad posted in a neighboring state that has references to the smell of cumin, curry, and oregano in the halls as a negative. So this is something that caught the attention of the local Fair Housing Center and is certainly something that we have seen in fair housing cases brought on national origin where people have disagreed over cooking smells and have discriminated against people because of how they cook related to their national origin. And so that's certainly a violation, and it's certainly not something we would encourage placing in an ad. It also doesn't tell us anything about the housing in terms of the number of bedrooms, amenities, granite countertops, what kind of bathroom, shower, what do we have here? It's not giving us any of that information about the housing, which is, again, a best practice, talking about the type of housing. and the amenities. So then we jump forward to 1974, where we added gender or sex protections. This is now interpreted, according to a HUD memo, to include gender identity and sexual orientation. So we have a federal interpretation protection in place, which has been there since February of 2021. You heard in the video, President Reagan signed an additional law in 1988 that added families with children and people with physical or mental disabilities, as well as enforcement mechanisms under the Fair Housing Act. So the 1968 Act did certainly establish the right to fair housing, but it didn't really allow for much in terms of complaint processing and enforcement. So that was shored up here in 1988, as well as growing our list of protected classes. Michigan was very proactive in the civil rights arena as well. In 1976, the Elliott-Larsen Civil Rights Act was passed, and this includes a housing section specific and adding marital status, whether or not somebody is married, and age, with the exception of older adult housing. And that also has been recently amended. So for those of you who have joined us within the last year or so, this is a significant change here in the state of Michigan. In 2023, we passed a Crown Act that added a definition of race to the state law for the first time, and it includes traits historically associated with race, such as hair texture and protective hairstyles like braids, locks, and twists. So this is something that is now part of Elliott-Larsen. It's illegal to discriminate against someone based on hair texture and hairstyles. It also added gender identity or expression and sexual orientation as definitions, so kind of a precursor of what to come under the Crown Act in 2023. We have these definitions, and we now have officially the amendment to state law to add sexual orientation and gender identity as protected classes in Michigan. So we're updating all of our materials, all of our training, all of our content to make sure we have expanded our list as of February of 2024. So earlier this year, the list grew here. HUD has the ability to accept complaints under their 2021 guidance, and the Michigan Department of Civil Rights here in the state of Michigan, which has the authority to enforce Elliott-Larsen Civil Rights Act, is also able to take and process these complaints now as well. So this is some homework to make sure that any of your fair housing policies, posters, information is inclusive of these new protections across the state of Michigan. I know there are some of you on the call who are not in Michigan, so that's something you want to look into is your own state laws as well as any local laws. Here in Michigan, we also have a Persons with Disabilities Civil Rights Act, which encourages housing providers to make accommodations and modifications for people with disabilities. Bree will talk a lot about that in the second half of our training today, as that's still an area where we do see a lot of discrimination. As Lindsay said, this is an area, the reasonable accommodations caseload was about a third of the allegations brought to our Fair Housing Center and has been pretty consistent. Quick question on the marital status protections. It is something that it shouldn't be a factor. So whether people are married or not and they want to live together, they have the right to do so under Elliott-Larsen Civil Rights Act. A requirement that people be married in order to occupy a unit would be problematic under fair housing law in Michigan. And in fact, we've had several cases where we did have a senior community require a couple to get married. They met as neighbors living in the senior community and wanted a 2-bedroom to move in together. And under their faith, they were going through the process of getting married, but the 2-bedroom was available and they wanted to move in quickly. She was 89 and he was 91, and they wanted to move together. As he said, we don't have a lot of time. And the manager wouldn't let them move in until they were married, and they came to us and we were able to rectify that violation and allow them to get the unit to move in together right away. Eventually they did get married, but they didn't have to, and they shouldn't have been required by a housing provider. So great question. Thank you for asking that one. So very small exemption under the law here in Michigan. It's really 2 units or less. If somebody owns essentially a duplex and doesn't rent out any other properties, they may have some small exemptions, but again, they would not be exempt from the race-based protections that we looked at as part of Reconstruction. So if you feel like you would fall into this category, you're welcome to contact us with questions, but essentially it's very safe to assume that housing in Michigan, especially if you're offering numerous units, it's going to be covered by fair housing laws here. Regardless of any exemptions that someone would have, they cannot advertise in a discriminatory manner. So going back to senior communities, for example, you can have an age restriction under federal law for 62 and older for all residents. That's under the Housing for Older Persons Act. They still can't advertise no children, for example. So we really encourage, if you have questions about advertising, that you contact us and recognize that advertising is broad. It's not just placing an ad, but it's your promotional materials, your website, any newspaper or internet ads, any verbal statements made, any communication must be done with fair housing in mind and in compliance with fair housing. And it goes back to that paragraph, that section 804 that we talked about, that kind of creates that broad definition and the liability under fair housing. Then you've got to do some homework. I saw a few people from quite a few different communities that had fair housing ordinances. Ann Arbor, for example, expands the list that we've looked at. So they have federal and state coverage, but they have added a good number here, 10 more or so, 12 protected classes within the city limits. So if you're working within the city of Ann Arbor, you need to be aware of these protections. Grand Rapids, this is kind of the greater Grand Rapids area where we work more often. Grand Rapids, East Grand Rapids, Kentwood, and Wyoming cities all have additional protections here, adding source of income, for example, medical condition. Height and weight are very commonly included because the civil rights laws often have an employment section, a public accommodation section, an education section, and a housing section. So, but they are protected classes, so we want to make sure you're aware of those. Source of income is essentially where someone's income to pay for their housing comes from. So it could be disability income, it could be wages, could be retirement, etc. Could be a housing choice voucher, things like that. We'll talk more about those. Holland and Kalamazoo within the last 5 years also extended their protections at the local level. So this is something that you want to definitely keep up to date on. You can sign up for our newsletter or connect with your local fair housing center to make sure you're finding out of any new changes to local law. We see a great diversity of protected classes. For example, political orientation is protected in the capital, Lansing, for the state of Michigan. But a community can choose whatever groups they want to be passed into law and to be protected from discrimination. So it's important to do the homework here, and we've provided some resources to check Michigan codes. There's online code libraries. These also would have other states, but we're focusing on Michigan today under our MISHDA grant. So heads up for Grand Rapids, Detroit, Kalamazoo, Kentwood, East Lansing, Muskegon Heights, Traverse City, Wyoming. Those all have additional fair housing ordinances that you need to be familiar with. We also have a number of bills pending here in Michigan, one of which would be the Fair Chance or Fair Chance Access to Housing law that would limit criminal history screening. So that's being introduced, and there was an open session on it, I think, last week. Ann Arbor, Detroit, Jackson, and Kalamazoo already have local ordinances that limit the ability of a housing provider to do a criminal history background check. So this is definitely a hot topic and something we'll talk more about as well this morning. But a quick question for all of you. And hopefully you're seeing this question. We are asking if you know if your property receives any federal funding or not. Because this is an introductory class too, we included the option of I'm not sure. And if you're not sure, I encourage you to talk to a manager, talk to a team member to find out, because when you accept federal funding, you have additional guidance that you must comply with. So it's really important to know how your property is funded and what additional regulations might apply. If you don't have any federal funding, you are not subject to these additional requirements, but we often recommend them as best practices. So we'll be talking about them a little bit more in detail. If you are looking for handouts, please message Lindsay in the chat. Okay, we'll give maybe 10 more seconds here. Okay, So we are trending towards most of you, 66%, with federal funding. So that's very helpful to know. About a quarter of you are in what we consider the private housing market, and 13% of you have some homework to do. So make a note, not only to know what your local local fair housing ordinances are, but also to check into how you are funded. So great. Thank you for that. Got a million things happening on my screen here. So, okay. Looking at groups that do have federal funds, you would be subject to the equal access rule, which actually there's three parts, three regulations that come under the title of equal access rule. The first one was put into place in 2012. You are directly linked to this. Any HUD funded programs covered by this rule cannot discriminate based on the composition of the family, whether it's adults and kids or just an adult household, for example, age, disability status, marital status, and actual or perceived sexual orientation and gender identity. So in 2012, there wasn't a lot of protections around sexual orientation or gender identity, especially at the national level or federal level. So under HUD programs, this was a significant step forward to kind of adjust the definition of family and be more inclusive of different family makeups. So here's a list of some of the programs that it would specifically apply to: HUD assisted and HUD insured. So continuum of care and McKinney-Vento programs for homeless individuals, Section 8, now called Housing Choice Vouchers. If you're funded under a city grant that is used using Community Development Block Grant Funds or CDBG, if you work for a public housing agency like a housing commission, a HOPWA property, supportive housing programs specifically for the elderly and or persons with a disability, if you have Federal Housing Administration insured loans, etc., you need to be familiar with this rule. There are great resources online and wonderful toolkits, videos, and scenarios to help familiarize yourself and update your policies if you haven't done this already. And of course, you want to make sure you're including the Michigan reference now for sexual orientation and gender identity or expression. So again, it's really broadening the definition of family. So any group of people presenting for assistance together with or without kids, regardless of their age, relationship, or whether or not any member of the household has a disability, they're considered family under this equal access rule. Under HUD's homeless programs, to distinguish a family from an individual, the household must include a child under 18, but that's specific to homeless programs only. A second rule was issued in 2016 relating to an individual's gender identity specific to temporary emergency shelters and similar programs, addressing how transgender and gender nonconforming individuals, using the language of the rule there, should handle privacy, shelter policy, and safety issues in order to be in compliance. So it builds off of the 2012 statute and kind of expands it for these programs specifically. There's also a Native American and American Indian rule that essentially adds sexual orientation, gender identity protections to programs funded under those dollars as well. So the 2016 rules apply to HUD's community planning and development or CPD programs. I'm using so much lingo, I apologize, but again, these are all in your handouts and we encourage you to reach out with questions. But this includes continuum of care funded agencies focusing on unhoused individuals. Oftentimes they have emergency solutions grants. It also covers HOPWA, Shelter Plus Care, supportive housing, and other HUD assisted programs. So you want to look at admissions, occupancy, and operating policies and procedures of those funded programs. It applies broadly. So recipients of the funding, subrecipients, owners, operators, managers, providers, including volunteers and contracted workers. So very far-reaching in terms of coverage under these rules. Switching gears a little bit now to violence against women, or VAWA. This provides specific protections for victims of domestic violence, dating violence, and stalking. We've also been able to, in the fair housing movement, challenge private housing providers with some protections under gender when there have been incidences of people treated unfairly because of domestic violence histories. So VAWA covers federally funded properties, but we do have some limited gender abilities in the private housing market as well. There have been proposals to add domestic violence as a protected class outside of federally funded properties, but it has not gained any traction here in Michigan at this time. It may be a local protection, like I believe it is in Ann Arbor. But victims of domestic or dating violence, sexual assault, or stalking cannot be denied admission or denied federal rental assistance because they are or have been a victim, or even if they're threatened with that. They can't be evicted or lose their federal rental assistance as well, and they can't be denied admission or rental assistance, evicted, or lose their subsidy for reasons related to the abuse, such as bad credit history or criminal history. So here's a pretty comprehensive list of VAWA applying to programs. So again, individuals who are seeking housing through these programs that are funded through these pots of money or different program names, or if they're a resident, if they're a current tenant in any of these properties, VAWA would apply. So low-income housing tax credit or LIHTC housing, very important to be aware of. ESG, as we mentioned, public housing, voucher-based or voucher project-based housing, continuum of care programs, as we said. So also rural development. So this is another, just a reminder of that homework assignment of finding out exactly how your property would be designated and funded. VAWA requires that communities honor any abuse protection orders that are in place and court orders like divorce decrees, especially those that address access to or control of the housing unit itself. You need to inform individuals of their rights under VAWA and include that information in lease agreements. In cases where both the victim and the perpetrator are parties to the lease, they're both named on the lease, the law does allow for the apartment community to split or bifurcate the lease in order to evict the perpetrator and allow the person who is subjected to the domestic violence to remain housed. I recommend you check out MSHDA's VAWA page, which is linked here. There's a lot more information, and we'll be looking at some of these more in-depth topics in our 201 and 301 classes as well. So again, denying admission based on someone's history or evicting someone because of an incident of actual or threatened violence would be a violation. Terminating a lease based on criminal activity related to domestic violence, dating violence, stalking, or sexual assault. Unless the community can demonstrate an actual or imminent threat to other tenants or employees, if the lease wasn't terminated, if the lease was otherwise terminated without that ability to document or demonstrate that threat, it would be a violation. So you'll commonly hear us talk a lot about documentation. It's very important for you to establish kind of the facts of what's happening and maintain that documentation so you can refer back to how any decisions were made really across the board under fair housing to show that the actions taken were not discriminatory and that due diligence towards fair housing was considered. Some suggestions that I think are just really good business practices aside, but these specifically can assist victims of domestic violence is making sure properties are well lit, safe, and secure. Obviously, completing repairs, especially for broken windows, locks on doors, things like that, prioritizing those as a safety issue, addressing them in a timely manner, acknowledging those protection and court orders and assisting with enforcing them, excluding the violent person from the premises, and staff may be called on to assist in the pressing of criminal charges. You must be very careful with victims' personal information, contact information. You cannot give that information to anyone without a release from the tenant, and recognize that domestic violence is not a lease violation. Other laws to be aware of, Section 504 is triggered through 1973 Rehabilitation Act for organizations that accept federal financial assistance. Same thing with Title VI. It's tied to those federal dollars prohibiting discrimination on race, color, and national origin in any programs and activities operated with that funding. There's also Equal Credit Opportunity Act coverage for individuals seeking home loans. I've mentioned Housing for Older Persons Act. This has to meet the 55 or older, 62 and older protections that we'll talk about in our second half in more detail. So we are focusing on those protected classes in detail here, but we want to look at some new HUD guidance that is not necessarily officially creating protected classes, but that we do need to be in compliance with. So getting to know your list of protected classes based on where you are working is really important, especially if you tend to rotate through a couple of different cities or communities. The list of protections can change, so really important to be aware of. And also, if it's a group that's not on your list of protected classes, Generally, they're not going to have fair housing enforceability there. I'd say, you can screen for credit history. We've seen policies against tattoos. We don't have physical appearance here in Michigan. We do, however, see a lot of activity around criminal history and criminal background screening. So we're going to look at that now. A lot of links here, and we will address these more in future trainings. But we've got guidance for public housing agencies or housing commissioners from HUD in 2015 with a very helpful FAQ document, a frequently asked questions document. I want you to be aware that there is a proposed rule that has been published. It was published this summer. So this is an indication of kind of the direction that I think HUD will go in trying to update the guidance on criminal records for public housing agencies. So you can use that rule to kind of assess the direction that we think the guidance will be going in. It's not in place yet, but it has been proposed. There's also guidance from 2016 and 2022 for the private housing market about evaluating applicants. We also have a 2024 set that we'll talk about as well. So again, not a protected class at the federal level, but clearly we have a lot of guidance, and this is a very hot topic. And the reason why this has become really a big issue that a lot of people are thinking about and working on is that nearly a third of the U.S. adult population has a criminal record of some sort, and it's often a barrier in accessing housing and employment and other things people need to re-enter into society. So, this got a little backwards here. The 2022 guidance sets out kind of 3 ways that screening can be illegal under fair housing laws, really related to race. There's a policy put in place that is meant to discriminate, or it's a neutral policy that once applied is discriminatory on the back end. So kind of when we look at who is denied or screened out, there's an impact based on race or national origin or another protected class. Any policy can be subject to an accommodation request on the basis of a disability. So this is something that would apply to any screening standard as well. The 2022 guidance really introduces the idea that criminal history is not a good predictor of housing success. It doesn't tell us if somebody's going to be a good tenant or not. This has been largely studied, and the sources linked to that right there. So it has led HUD to say, for private housing providers, maybe screening isn't the best way to figure out who's going to be a good tenant for you. So they kind of introduced this idea and built on it from 2016. They're working on best practices. There's some good videos and tools out there. We have a fact sheet that you were provided with on your handout email as well. Some of the examples that HUD gave in 2022 of potential violations is not telling everybody about your policy, all applicants, and then not applying a policy, if you have one, to all applicants consistently across the board. So if you reject someone who's comparably qualified based on race and accept someone else who has a similar criminal history in a different race, that would be a violation. Discouraging some people from applying and encouraging others, withholding applications, offering some people applications. Again, those inconsistencies can be tied to race and are problematic. Another example was a post-housing. So a housing provider evicting a Black tenant who's convicted of a crime, but not evicting a white tenant who's convicted of a similar crime, brings that back under a race-based allegation of housing discrimination. Another example they gave was a property management company. This is always a red flag, departing from standard procedures. So anytime you depart from the normal, you want to have a fair housing assessment. And this example is a violation because they departed from their normal standards and screened someone because they learned that they had been previously homeless and hospitalized for treatment of a mental health condition. So they deviated and did a criminal background screening, and HUD said that would be a violation to do that. There's brand new guidance from April of 2024. It does kind of look at artificial intelligence and how we rely so much on online services, third-party screening companies, and what the implications are under fair housing law for potential discrimination. There's 2 documents that were issued in April. We're going to look at more detail of the tenant screening process document, but there's also an advertising document. So if you have responsibilities that include advertising, I encourage you to check out number 2. And we will obviously be including more of this in our 201 and 301 classes. But the screening of applicants, April 2024 guidance really discusses how housing providers and companies that do tenant screening as a service can screen in a non-discriminatory way and offers best practices for Fair Housing Act compliance. The fair housing laws apply regardless of what technology is used to make the housing decision. So these screening services are covered, staff making decisions are covered, and this kind of helps set that out. It includes common issues that have been seen and also suggests some best practices. So these are really well written and really well resourced. I encourage you to check them out, especially as you're looking at making sure any screening standards are up to date and in compliance. It has a section on guiding principles that I think are building on some of the things that we've seen since 2016, 2022, and some of the big cases that have been settled around criminal background screening standards. And they really do focus on common sense. So you want to look at relevant screening criteria. You want to use accurate records. So any bad information should not be utilized. Inaccurate information is very common in criminal history records. So accuracy is really important. You want to follow your policy. You want to be transparent with applicants. And most importantly, allow people the opportunity to challenge negative information. It may not be correct. They may have more information they can share on the circumstances, but allowing for that individualized assessment is really important. And then screening companies really should be looking at testing their models to make sure they're in compliance with fair housing and that their standards that they're using are not discriminatory. So if you are using a third-party screening company, that's a conversation that should be had and documented. They need to be aware of this guidance and they need to be taking steps to make sure they're in compliance. They also have a section on additional considerations that I think are really indicative of kind of where HUD's thinking on this is going. And again, HUD is not only a funder and a housing provider, but they have authority over enforcing fair housing laws. So they've identified areas where there may be an unjustified discriminatory effect in screening on some of the protected classes, including race, color, national origin, people with disabilities, women specifically, and families with children, as well as survivors of domestic violence. And they identified credit history, eviction history, and the use of criminal records as these considerations. So really interesting to read this section. I encourage you to check it out. For credit history, they're finding, credit scores were essentially developed to assess somebody's risk as a loan recipient, and we're using it in a rental transaction process. So, is it really helping us get the information that we need? Is it telling us if they're going to pay their rent or not? And it's not a guarantee. So is there another way we can get at that, answer those questions? So it might be simply income verification. Eviction history, what do we need to know about the eviction to find out if they can be a good tenant now? What were the circumstances when it happened? Why did it happen? What if it was really long ago? Or the circumstances no longer apply? Maybe they've degree, maybe they've gotten a raise or a promotion in their employment. Those facts can really matter and help people access housing. And then the third section, of course, is criminal records. So kind of shifting gears to looking at best practices in screening in the use of criminal backgrounds, we have kind of two sections of procedures and policies, and these are on the fact sheet that are part of your handouts and that you can find on our website. But, per HUD guidance, maybe no longer using criminal history to screen tenants would be appropriate. You, of course, want to keep an eye on state and local laws. As I mentioned, there's a state law pending, and there's few cities in Michigan that have laws that limit the ability to run these checks. If you have federal and state funding, you've got to check for program requirements, regulations, or restrictions tied to those dollars related to this screening. Avoid third-party screening companies that use biased algorithms. That you really have to challenge those companies to make sure they're in good compliance and aware of fair housing. Having a written policy that's available to applicants and staff is really important. You may want to consider delaying consideration of criminal history until first focusing on financial and other qualifications. And of course, you want to treat comparable criminal histories similarly across the board. Before denying someone or evicting a resident, give them the information, give them the opportunity to correct wrong information or explain those extenuating circumstances that might be there. Only evict per HUD for criminal activity as a last resort and after that individualized conversation or assessment. Never evict someone because they've been a victim of a crime. Do not ban tenants' invited guests from visiting based on guests' criminal involvement. That's directly from the HUD 2022 guidance. And of course, you want to document all the screening that you're doing, the circumstances considered, the decisions that you made, and maintain those records for up to 3 years. It's the longest window in Michigan to have to respond to a complaint. You want to look at what happened, the nature, severity, and how long ago the criminal conduct occurred. You want to make sure that your policy is justified with the standards really being tied with keeping residents and property safe. So any standard that's in place that isn't tied to resident or property safety is something that should be taken out or updated. So differentiating between homicide, sexual assault, arson versus gambling, prostitution, tax or cyber crimes, etc. You cannot have blanket bans. Those have been successfully struck down in a number of big cases. You do not want to consider arrest records only. You really need to look at convictions and avoid any automatic denials, blanket bans, etc. And you can also consider the amount of time that has passed. I mean, we've talked to individuals who have records that are 30 years old, they've not reoffended, and it's still a barrier for them to find housing. We cannot emphasize enough that individualized assessment is very important. You want to make sure you're offering that on a consistent basis as well. But this is an important exchange of information where they could share, maybe they've had a good tenant history somewhere else. They've been able to graduate from a program that helps rehabilitate them, whatever the case may be. And of course, you have to consider any reasonable accommodation requests to this policy on the basis of a disability. PHAs, so if you're a public housing agency like a housing commission, you're subject to the 2015 guidance right now, excuse me. There's some hard musts that you have to comply with. So PHAs and project owners must deny admission to anyone who's been convicted, not arrested for, but convicted of manufacturing meth on federally assisted property, anyone subject to lifetime registration for a sex offense, and current users of illegal drugs, abusers of alcohols, or anyone who has a pattern of interfering with the health, safety, peaceful enjoyment of others on the property, and anyone who within the last 3 years has been evicted from federal housing for drug-related criminal activity, unless they've been through a rehabilitation program or the circumstances leading to their eviction no longer exist. So these are must deny situations. May consider denial here. These are not requirements. We often find that people believe this is required, but it's not when you look at the guidance. So they may consider denying admission, evicting, or terminating a lease for drug-related criminal activity. Again, that manufacture, sale, distribution, use, or possession of illegal drugs. For violent criminal activity, use of or threatened use of physical force that would cause bodily injury or property damage, or other criminal activity, again, tied to that having a negative effect on health, safety, or right to peaceful enjoyment of the other residents, the owner, and the employees as well. So this is optional. There is no requirement to have a one strike policy. That's something that we have heard off and on over the years that one strike and they're out. We have to do that. That is not accurate. You have the discretion to deny, evict, or terminate based on certain types of criminal history, taking into account, very similarly to everything else we've looked at, seriousness of offending action, effect on the entire household, meaning those not involved, any steps taken by the leaseholder to prevent or mitigate criminal activity, and participation in rehabilitation programs. So, these unique circumstances matter and need to be considered. You want to make sure you're using accurate information as well to have these conversations and assessments. Those of you who are in LIHTC or low-income housing tax credit housing, you want to look at the LIHTC compliance manual. It defers to the HUD handbook. We've got kind of the trail of crumbs here, but also directly link what HUD is outlining for their criminal background screening criteria. Owners must establish written screening criteria. So again, this is for this program only to prohibit admission of certain individuals who've engaged in drug-related criminal behavior on the state lifetime sex offender registration, or individuals whose abuse or pattern of abuse of alcohol interferes again with kind of that health, safety, and peaceful enjoyment of others. Owners may choose to expand these requirements. It's not required that they expand it. They can choose to expand it regarding the prohibition of admission to certain applicants. So I think a lot of folks have been kind of trained or told these are the hard lines. So it's important to make sure that you're using accurate information to inform your policies. And if they haven't been looked at in a long time, which is something we hear very often in a lot of our casework, we've done this forever. Well, things are changing. So it's important to do the policy reviews and make sure the updates are in place to be in current compliance. So, okay, we'll take about a 10-minute break. We covered a lot of information, so please feel free to stretch your legs. We'll come back at 10:25. So we'll take a 10-minute break here, and thank you all so much for joining us this morning. We'll talk to you again shortly.
Right, welcome back, everyone. Hopefully, everyone got another cup of coffee, some water, went to the restroom, things like that. I got some water for myself. All right, we'll get back into the swing of things. So now Liz went over a lot of good content. Now I'm going to dive deeper into the protected classes and how they are defined and some examples and things like that. So feel free to continue to ask questions in the Q&A. And yeah, we'll get started again. So first up, we have race, color, and national origin. Race refers to physical characteristics, which can include hair texture, skin color, eye shape, or other differences related to race. Color is differentiated because that refers to a person's skin color, because people that are different races can also be different skin colors. Some Hispanic people are lighter skinned, and some Hispanic people are darker skinned. So, and we have seen different differences of treatment based on that as well. National origin refers to a country of origin or where somebody is from, or somewhere ancestors are originated from. Additionally, and this is kind of is true across all the protected classes, but the perception of someone's race, color, or national origin is also protected. So if you perceive somebody to be a certain race or a certain color or a certain national origin, and that's not how they identify, and you discriminate based on that, that is still against the law. And that kind of goes across any of the protected classes, which will be highlighted. So disability, if you perceive somebody to have a disability and they don't, and you discriminate, that is still protected under law. A case that comes to mind for race and color was one that was here in Michigan. It was an older gentleman who was Black, and he was looking to move closer to the hospital and closer to a place where he could be close to his doctor's offices as he was receiving treatment. And he found a senior community that he was really interested in. It was right next to where he needed to be all the time for his treatments. And so he applied there. He got very friendly with the leasing agent. She knew all about him. He was from California. He was an engineer. She knew about his grandkids. He would call regularly to see where he was and when a place would open up. And they were very friendly. And one day he came home and his neighbor was moving out, his white female neighbor, and he asked, where are you moving to? And she said, ABC senior living community. And he was like, oh my gosh, he was really excited for her. He was like, I've been waiting forever. How long have you been waiting? And she said, oh, I've waited 2 months. He kind of, it was jarring to him. And he had been on the wait list for 7 years. That was found that they were maintaining wait lists based on race, different wait lists based on race. So he was on a different wait list because he was Black, and she was on a different wait list because she was white. And so he didn't ever actually get the opportunity to live there. He has since passed away. His family has pursuing that case in his in his estate. And so when we think about fair housing, and, Lindsay talked about this a little bit as well, but we think about all the factors that housing affects in our life. I think this case always stands out to me as like he chose that housing because it was close to medical care, and his medical care probably, was affected because he was not able to have housing that close to. We did hear that he missed appointments, and because the bus wasn't always reliable, and things like that. So these are just things to be thinking about when we think about discrimination and how it affects people's lives. And that case is a sad one, and it was one of the first cases I heard when I got joined onto the Fair Housing Center, and it has stayed with me because it's a pretty a strong case. Additionally, HUD has put out a new fact sheet for federally funded agencies. And this is based on actual or perceived shared ancestry or ethnic characteristics. And again, it kind of just goes into that, telling people that they can't live in an area because there's no religious communities nearby with the same names, appearances, accents, races, or ethnicities, harassing tenants using racial, ethnic, or ancestral stereotypes or slurs, refusing to rent because of their name, the way they dress, or other characteristics associated with a certain ethnicity or ancestry. So it kind of just adds on to that. This is something that is serious and that needs to be looked at when people are being prospective homebuyers or applicants are applying. They should not be treated differently based on any race or ethnical backgrounds. National origin, there's some additional protections for those who are receiving federal funds to kind of look at people that have limited English proficiency and how that's kind of tied to national origin, and having making stereotypes or making claims to not assist people that maybe do not speak English could also be a national origin discrimination. There's a relation there. So restricting access to housing on the basis of LEP, which is limited English proficiency, can have a base discriminatory effect on national origin, race, and other protected characteristics. So, looking at standards and how you are treating those who may not speak English, if you're treating them differently or requiring them to speak English on your property and things like that, that is protected, especially when you're receiving federal funds. And the LEP guidance in there is linked. And here's just some more examples and some practices that we have seen and heard about, turning away applicants who are not fluent in English, blanket statements saying all tenants must speak English, treating someone differently, refusing to work with them because they speak a certain language is a big one. And then those LEP guidances for HUD properties are linked there. I will say that, that's more of like, for funded properties, there's more an obligation to serve people that are limited English proficiency, but these things are also protected in the private industry as well. If we heard about a statement that was all tenants must speak English, that would be a fair housing red flag for us, and how those people are being treated differently because it is tied to national origin. Up next is sex and gender. So under the Fair Housing Act, sex and gender are protected. And additionally, sexual orientation and gender identity are also protected. So gender preferences can only really be used in advertising for roommates or if there's a shared living area like a kitchen or a bathroom. Some examples of discrimination that we have seen is a lot of times it's based on biases and that a woman may not take care of the landscaping, so you don't want them living there because they're not going to mow the lawn, or they may need a lot of repairs. Some like having those biases about gender, and then using those to allow who lives in your unit is protected. Moving on to disability status, it is pretty broad. It covers both mental and physical disabilities, and it's defined as having a impairment that limits a major life activity. And then additionally, as I mentioned, being regarded or perceived as having that impairment and then having a record of such physical or mental impairment is protected under fair housing law. And when we think about major life activities, it's very, very broad. It's anything that can affect your physical, mental, or social activities and working. So sleeping, walking, bathing, eating, seeing, hearing, driving, those basic needs that help you live life. If those are affected, then that would be cause for a disability-related protection. We've had many cases, as shared in the beginning, as disability is our number one allegation and caseload that we have on our team. So we have lots of experiences and a lot of cases to call from, but one that we've shared in the past, and maybe people have seen the video, but we had a client named Sherry who was living on the second floor of a unit, and she couldn't use the stairs well due to her disability. Additionally, the stairs were in really bad condition, so that was another factor into it. And she was, because of that, she was not leaving because she was scared to use the stairs. And then she'd requested a first floor unit. And then once we got involved, and they denied it, once we got involved, we were able to help advocate to get her to a first floor unit. In the meantime, she did lose her assistance animal in the time because he had fallen down the stairs due to their bad condition, well, she fell down the stairs, I should say, and then he fell down to help protect her, and then passed away in the process. And so, but she was in that story and in that video we often share, she shares how being restricted to her unit was really really challenging, because she wasn't going and getting groceries. She would miss the bus because the go bus would be like, I'm here. And then she would take a minute to get down the stairs and it would be gone. So there's a lot of factors that affected her life by not having that first floor unit due to her disability. And that is something that tenants can request. They can request if the unit is no longer fits their needs, their disability-related needs. They can request to be moved to a different unit. And if there's no units available, it's kind of a last call effort. They can ask to end their lease early with no repercussions because the housing no longer fits with their disability-related needs. Additionally, we get a lot of questions on this. It is allowed to have, lease violations or lease agreements to say no smoking or no drinking, or similar behaviors, but you cannot discriminate against the person with the health condition, because alcoholism and drug addiction and addictions in general are considered to be disabilities under fair housing law. So you can say no drinking, but you can't say no drinkers. You can't associate that with the person, but you can have those clauses saying no drinking and no smoking on the property. Under disability, there are two types of ways for people with disabilities to continue to live in their units happily and successfully. And one of those ways is a reasonable accommodation. And that is a change in rule, policy, or procedure or service for that person to have equal access and enjoyment of their housing. So this is you having to change your policy or your procedures for this person to be able to utilize the property. A big example would be waiving a no pet policy if they have a person with a disability has an assistance animal. Additionally, we are seeing a lot of assigning designated accessible parking spaces. So if a person needs a space that is closer to their unit, yes, many places have ADA accessible spots, but that is under ADA. Fair housing allows for a person with a disability to request a specific designated parking spot, as those ADA spots are for anybody with a disability. It's not specific to that person living in that unit, and that person may need that based on their disability. They may not be able to walk far due to mobility issues or heart conditions, things like that. And I see
And
Liz
the ADA, yeah, I just want to say, because acronym soup today, the ADA is the Americans with Disabilities Act, which we are not experts in, but we work closely with disability networks, centers for independent living. Every county in the state of Michigan has a disability advocacy group essentially covering, many of them cover multiple counties, and we partner with them locally because they are experts in ADA, or Americans with Disabilities Act, which would cover kind of the public access parts of an apartment complex or community, like a community room, your sales office, and then the public parking.
Thanks, Liz.
Mm-hmm.
And with reasonable accommodations, I do want to add, it's usually the responsible of the housing provider to pay for anything that may be accustomed to that, because that is your policies and your rules that you have to accommodate. So yeah, if there was going back to the accessible parking space, if, a new stripes need to be drawn on, and parking sign needs to go up. Again, that would be a cost that the housing provider has to take on, as it is an accommodation to have that accessible parking space. And then linked here is it's a really, really great document. It's a lengthy document, but it's a Q&A type or frequently asked questions type document on the HUD DOJ joint statement on reasonable accommodations. And that is linked there. And no, we did not provide it. It's linked here. When getting, say you receive a reasonable accommodation, these are kind of the questions you may ask yourself or think about when processing it. So think about, what are the existing policies or rules? What do they say? What is the standard procedure, and how is this request different? Do you need documentation? Do they have a visible disability? If they do have a visible disability, then you do not need documentation to say that they are a person with a disability. But if they have an invisible disability, as many disabilities are, you may need documentation to substantiate that this is a person with a disability and they have a disability-related need for their request. And then when or how does the policy get changed? And all these questions, may require some homework for you looking into it, talking to maybe corporate office if needed, advocating, and, if policies need to be changed to ensure that this person with a disability can get what they need to live there happily and healthy. However, if you do have questions on that process and you're a little confused, that's something that we can help with. Just ensure that we may come back with more questions. So sometimes it's a go back and forth procedure with us, because our answer is it depends.
Yeah. And we often need more information to make sure we're using the right set of laws, whether or not you're federally funded, geographically where you're located. And we do have a great question in the Q&A. It's not necessarily a disability related request, but they're asking about somebody who cannot read or write. What would be an accommodation for them to read posted notices on bulletin boards, policies and procedures, et cetera. And I think it'd be appropriate to work with that individual one-on-one and ask them how best they receive information. I think one offer would be to make sure there's some sort of verbal review, but really working together to figure out what meets their needs would apply absolutely with persons with disabilities or someone with the barriers for reading and writing as well. So, and there's a request for sample accommodations policies, and that's something we can follow up with you on too, Susan. Yeah.
Yeah. Thanks, Liz. Yeah, I did forget to mention that. With any reasonable accommodation and modification, as we move into that on the next slide here, you really want to work with the person with the disability to see what best fits their needs. If what they requested is not feasible, is not reasonable, which we'll talk about, it can't be just a straight no. It has to be a no. And what is the alternative? What can you offer? And it's a interactive process, as HUD calls it. So it is a mutual process between you and the person asking for it. Of what can you do as a housing provider and what best fits their needs? But often you let the person with the disability lead kind of that process because it's what they need so they can live there.
Mm-hmm. And then the question is, what's reasonable, which we'll get into.
Yes. And reasonable modifications, moving into that, those are structural changes or physical changes to a unit or housing structure. A big example that we often see is a ramp to an entrance, but that could also be grab bars. It could be trying to think of other ones. Those are the two main ones, but
different. It's taking out a round doorknob and putting in kind of like a lever style handle is a fairly common one, or lowering a workspace in the kitchen.
Yeah. Things like that. So, and must be allowed when reasonable for the most part. You can ask it to be done in a workman-like manner. But if you receive federal financial assistance, so if you're a HUD funded property or USDA or other things like that, does then turn into an accommodation and must be paid by the housing provider. unless it is unreasonable, which we'll talk about, like we've mentioned a couple times here. But if you are a private housing provider, modifications are generally paid for by the tenant. So if there's a ramp that needs to be placed, then in, a single family home, if a ramp needs to be placed out in the front, that would fall on the tenant. And then again, there is the HUD DOJ joint statement on reasonable modifications, similar to the accommodation one that is linked in the PowerPoint.
Yeah, and the question of payment too is also, is it for their individual use, or, if you're putting in a ramp to a public or common area, then the housing provider would maybe split that cost as well. So it's going back to what Bree said, it depends. But here's some helpful questions. There was a question in the chat about payment. So
thank you, Liz. Yeah, so again, as we talked about with accommodations, these are kind of the things you may need to think about or question when processing modifications. Who will use it, as Liz talked about. If it is a community thing, then it may be a split between you and the tenant. You may end up just taking the cost on that because it would affect all the tenants in that space. Things like that. Will be there. Is there any issues with code compliance? Again, I said you can request that it be done in a workmanlike manner, but you can't put something into a wall if it physically cannot hold or structurally hold it. Is there documentation needed, as we talked about, plans or drawings? Who pays for it? As we talked about, private housing, generally the tenant pays for it. Federally funded housing, the housing provider pays for it. What happens when the tenant moves out? That's something to think about. Talk with the tenant about it. But again, all of it requires homework, working with the tenant, working with maybe your corporate office about it. However, we can help answer any questions. We do have a guidebook with sample response form on processing these, so feel free to check that out as well. And then these are just some additional information on modifications and accommodations. They can be requested at any time. Tenants with unobservable disabilities or disability-related needs can be asked for documentation. Tenants can request more than one. And the request must not create an unreasonable burden on the housing provider. A good one would be like not getting paid rent. Another one would be if they don't have transportation and they can't use their own car because of a disability and they have to use the bus system, and they request for you to provide a shuttle. Well, that would require you to hire somebody to staff the shuttle, buy a shuttle, and that would be unreasonable. That would be financially unreasonable for you to provide as an accommodation or modification. However, we can all help process those things. If you have some tricky ones, you can definitely call us. Looking at some examples here, this would be a good example. There is a clear pathway. The signage is really good. Everything is marked really well. There is a I don't know how to ramp to go up into from the pavement. There's no step there, I should say. But then we look at this bad example. This was actually submitted in court as I did provide a good wheelchair accessible route. They just stuck a sign on the stairs. It feels like a really bad joke every time I see this. Like somebody was trying to be funny, but it was not.
I'll just say the judge was not amused.
Yeah. Now looking at assistance animals is a very hot topic. In January of 2020, HUD did put out some guidance on assistance animal, and it did replace any guidance from 2013. It does not address Section 504 or the ADA, but it is a good piece of guidance to use in conjunction with those joint statements that I mentioned earlier. It should be applied going forward. Do not reassess any requests. And there is a second section in it that can be used to help educate on documentation, which is also provided. This and the other second section was provided in the handouts. For assistance animals, there are two types of assistance animals. So you think of assistance animals as the umbrella term. And then underneath that, you have service animals, which are animals that are also allowed in public spaces. Those are trained animals. And then the other is support animals. So they can be trained or untrained, and they provide tasks, assistance, perform therapeutic emotional support with individuals with disabilities. So there's two types of assistance animals: service animals, which we think of the ones that can go into the supermarket, on a plane, and then support animals, which tend to fall under the emotional support, but they can also provide assistance in other ways. Looking at this guidance, it is really, really great. It walks you through a series of questions of a if then what type of situation, a kind of decision-making tree there. And it kind of is if it starts off with whether the person, or sorry, whether the animal is a dog, if and it's an individually trained service animal. So, and then it kind of has a little section about service animals, and then it really transitions. Most of it is about support animals and how to process a request for assistance animals. It does look at maybe information you already know about a disability and disability related need. So be thinking of that when thinking when looking through this guidance. We also have a resource guide that is more to pair with it. It's something that we made after reviewing this because it is a lengthy document, and it kind of pulls out some of the highlights and some of the things that we've found important to highlight. So feel free to take a look at that as well. And that was provided in the handouts. Some quick things that we get a lot of questions on. Assistance animals, no fees, no deposits, pet rules, limits, or size restrictions there can be no limits or things for support animals or service animals. If you have a breed restriction on your property, if it is an assistance animal, it does not apply. Pet rules do not apply. We did provide a sample assistance animal policy because there are certain standards that you can hold your tenant to if they do have an assistance animal, like taking care of the animal, ensuring that you dispose of waste properly, things like that. If there's state law or local law that requires registration or vaccinations, that can be included, but it is different than your pet policy. The assistance animal policy is important to show that you, as a housing provider, differentiate the two, and that there are different obligations based on if it's a pet or an assistance animal. We like to think of an assistance animal as a device, a disability device. It's not an animal anymore or a pet anymore. It is that wheelchair. It is that aid for that person with a disability to be able to live happily in their home. However, another big question we get, you can charge for damage if that is your usual practice. So at the end, if the beginning you collect a security deposit, and at the end you assess for damages, that if that's your normal procedure, you can do that for an assistance animal. So at the end, if there is damage to the floors, to the walls, or anything because of an animal, you can deduct that from the security deposit. If the animal poses a direct threat, you can refuse the accommodation if it cannot be eliminated or reduced by any other actions that the individual can take. So it kind of is, you have to work with that person to ensure if they can control or maintain that animal. Maybe they need a muzzle, maybe there's different actions that need to be taken to ensure that they are no longer a threat to the other people on the property. However, if that cannot be eliminated or reduced, you can refuse that reasonable accommodation. And as I mentioned, it is the tenant's responsibility to feed, maintain, care, and control of their animal. But they can do this if they need assistance with friends, family, or volunteers. A person can request more than one assistance animal. However, they need to show supporting documentation to say why they need each animal, why each animal assists in their disability. And there is no limit stated in the guidance. Housing providers cannot require a specific form or process. They cannot require detailed medical information. That is a big fair housing red flag. So if you are requiring a specific form to be filled out for assistance animals, I would definitely look into talking about getting that off your policy, because that is a big no-no that is called out specifically in the guidance. If you get a request, you must respond within 10 days. And then again, pet rules do not apply. We're going to really hammer that down because that is a big question that we get. So pet rules do not apply. No bans on breeds or weight limits.
We also had just quickly before we move on from assistance animals, there is some guidance in the 2020 assistance animal HUD memo about the type of animal. If the animal is a dog, cat, small bird, rabbit, hamster, gerbil, other rodent, fish, turtle, typically any sort of small domesticated animal that's traditionally kept as a pet in a home, HUD has said that is more of a category that those requests would be reasonable. If it's any other type of animal like a monkey, kangaroo, etc., barnyard animals, it's not automatically a no, but they need to make a case for a unique animal. For example, a service monkey would be able to open pill bottles, something that a golden retriever wouldn't be able to do.
Thanks, Liz. Then thinking about supporting documentation, a big thing to think about is, what do you already know? If this person receives disability income, then you may already know that they are a person with a disability. If you can see that they are a person with a disability, then those are reasons that you may not require documentation. And additionally, if the disability related need is not readily apparent. So you know that they receive disability income, but that's all you know. So you may need more information to say, okay, what is your disability related need for this assistance animal? So again, if you already know they are a person with a disability and they have a disability related need, no documentation is needed. If you do not know, that's when you can request documentation to support those claims. And then again, if really what is needed in documentation, it needs to confirm that they are a person with a disability as defined by law, and they have a disability related need for what they're requesting. So there has to be a nexus between the two. Approval and denial of request depends on the circumstances presented and should be determined on a case-by-case basis. However, it is super important to document every step taken. It's also really important to ensure that all your information is kept confidential. And then a big note, the person with a disability have the most accurate knowledge about their limitations posed by their disability. So again, work with them, understand what their needs are, and see how best you can make it work. And then thinking about reasonableness again, it is looking at if there is an undue financial or administrative burden. Would the accommodation fundamentally alter the housing provider's operations? Those are kind of things you want to be thinking about if it's reasonable or not. As I mentioned, there's a few examples previously. If the original request is found to be unreasonable, what are the alternatives? You must provide alternatives.
So Bree, before we move on to familial status, we have a couple follow-up questions in the Q&A. First, do we have to allow a resident's guest to have their ESA on the property? We normally have a no pets policy.
Yeah, that's a really good question. We have received from the Michigan Department of Civil Rights that guests with emotional service animals should be allowed on the property, and their emotional service animals should be allowed on the property. We don't have guidance on that, but that is from the Michigan Department of Civil Rights, who enforces fair housing laws in the state.
And other laws.
And others, yes.
Yeah. What kind of documents can a PHA require for proof of some emotional support? Kind of piggybacking on, can you ask for proof of ESA or service animal? These are things that I think we did address, but just want to reiterate. It
Yeah,
depends.
it depends. Yeah. And
Can you observe any disability? Do you know of a disability? Is there any disability related need that you know of?
yeah. Yeah, and documentation, I did not mention this previously. HUD calls out it can be from any healthcare professional who has essentially intimate knowledge of your health, and can say that you are a person with a disability and disability related need. So it's really just a letter that can show that from a healthcare professional. It doesn't have to be a doctor. It can be a therapist. It could be a social worker that you may be working with on a regular basis because of your disability, things like that.
Someone familiar with the care of the individual can verify that need. Absolutely. Another question, if we require our tenants to have renters insurance, can we require them to have their ESA or service animals put on their insurance?
Yeah, that is a great question. We get that question quite a bit. It would be considered a financial burden to have them have additional insurance. If you require all tenants to have renters insurance, that's, then you can still require them to have renters insurance. But if there is an additional burden, financial burden to have them add a pet, that would be an financial burden for the person requesting it, and any financial burdens cannot be put on to the person.
Yeah, it's essentially penalizing them for having that assistance animal. So if their insurance rate would go up to have that animal covered, you can't do that. Same thing if you put in a ramp or grab bar, contingent on insurance for that, that's explicitly prohibited by HUD guidance.
Yeah, and there are ways that tenants can advocate for that, not because it's considered an assistance animal and not a pet. But currently at this point, insurance providers don't have that differentiation, so that person can advocate for that, but it is a uphill battle for them to advocate that they shouldn't have that additional financial burden put on them.
So a question on HUD guidance on the request of more than one animal and providing documentation. Is this for ADA only or ESA? So I think what that question is getting at on multiple animals is essentially all assistance animal requests in housing are covered by the HUD guidance and federal fair housing laws. So it's something they're requesting to keep in their housing with themselves. And so that is fair housing law that covers that. The HUD guidance does not prohibit multiple animals, but they do need to substantiate or verify that they need multiple animals. And then we've got a couple questions about what about documentation online? Bree, if you could address that. What if tenants get an ESA, I'm assuming letter off the internet, but they don't have ongoing care as part of that relationship? Can you address that?
Yeah.
Briefly.
Yeah. It's reasonable to ask them for to ask for additional documentation to say that this is a person that is a treating physician for you on an ongoing basis. So it is, you can ask for more information to meet those kind of check marks that the guidance calls out. So that is one of the things that they do state, is that this person has that this is a person that you are seeing on a regular basis. So they would have to substantiate that with additional documentation. So you could ask for, for them to be adjusted, because there are often because of this guidance was written right before COVID. So a lot of people have transitioned to online healthcare. So a lot of people are seeking people online as healthcare professionals. So it just depends if they bought it from a website, then and it says it on the website, it says like ESA.com on the letter, then that's for you to say, okay, I need proof that this, you're receiving care, it's a healthcare professional that you're receiving care from on an ongoing basis. And that is permitted for you to ask for. Okay.
Thank you. Nope. We've got an accommodation request, a fully accessible unit with a roll-in shower. units with cutout tubs and units with regular tubs. So they offer kind of all three. They have an applicant who can't use the cutout because of limitations on lifting her legs, and they want a walk-in shower. This applicant doesn't want the fully accessible unit because there's no cabinets under the sink and the counters are lower. Walk-in showers are expensive, must we pay? So this is an anonymous request, and we'd really encourage you to contact us with more information. We need to know if you're subject to 504, the Rehabilitation Act, and if you have any federal funds. But generally, that would be a situation where I think making the modifications to the kitchen might be more beneficial to change the bathroom because the rest of the unit meets their needs, just without having more information and not knowing what law applies there. So I would encourage you to contact us with more facts, and so we can provide the right type of guidance. And if you do have kind of detailed scenarios you'd like to run by us, it's really helpful if you do contact us, because we do want to make sure we get through all the content in the training, even though we love questions. And then a quick question on allergies. What if a current tenant is highly allergic to, say, a type of cat, like Siamese cats, and someone wants to move into the building that has that cat? And what HUD has said is generally, you have to work with accommodating both parties. If it's a severe allergy, like I have a severe rabbit allergy, and spending time in a room or an enclosed space with a rabbit does inhibit my ability to breathe easily, then that may rise to the level of disability. And essentially, you have two people with disabilities, and you need to look at kind of what options and alternatives you would have to accommodate both people. So these cases and questions can be so fact specific and very unique, which we appreciate. And that's why this is a gray area of the law. We have to kind of be informed by the type of housing we offer, how many units might be available, how many options may be available within the housing providers, menu of properties. All of those unique facts really matter. So appreciate those questions, and that's why we make ourselves available as best we can to answer them beyond these trainings. So I think we'll move into familial status next, and then we'll circle back to questions as we can going throughout the rest of the training.
Yeah, and just a reminder, please put all questions in the Q&A, because we cannot guarantee we'll get to any questions that are put in the chat, because it can get lost there.
Yeah, there's a lot happening here that we're trying to manage. So
yeah. Please put them in the Q&A, otherwise your question may not get answered.
And I'll keep working on them as I can, but thanks everybody. This is great interaction.
Moving on to familial status. Familial status refers to whether or not there are minor children living in the unit under the age of 18. And it is unlawful to discriminate anyone because of familial status. What does this include? It can be a single person with children under the age of 18. It can be somebody that's pregnant. It can be people that are in the process of securing adoption or legal custody, people that may have foster children, grandparents raising grandchildren, siblings raising siblings, things like that. That is included under familial status. So it's really the presence of children under the age of 18 being in the home. Big examples that we have, very broad ones, is often steering to different buildings or floors. Oftentimes, housing providers may think that they're looking out for the best interests of the family. Maybe the family wants to be in a building with all kids so they can be friends and things like that. Or you are concerned for the safety of the children being on the second floor and there's a balcony. These are very, good concerns that you have, and you can be understanding that you're trying to look out for the family. However, you're removing the choice, and that's all what fair housing is about, is housing choice. So that choice needs to be provided to their family, and then that is their choice to decide if they want to live, in the building with the children, or if they want to live in this other building or on the second floor and things like that. So all options need to be presented. Additionally, there are some people that think that this is a law, and it's not. So children having children of different genders or sexes having different bedrooms are required. That is not a required, that is not a real law that is out there. So just be thinking of these things. So if it is, a four-person family, two parents, two kids, and you have a boy and a girl, a two-bedroom would be fine. They wouldn't need a three-bedroom if there are occupancy standards that allow for that, which we'll talk about in a minute. And then looking at marital status, that is whether or not somebody is married, widowed, single, divorced. Liz brought up a case earlier in the training with the elderly couple who wanted to live together, but they were not married. That is a protection in the state of Michigan. So that is protected in Michigan. So you cannot use that as a basis of discrimination, whether someone's married or not, if they can live together. Looking at occupancy, occupancy limits must comply with all local laws, regulations, or financing requirements. So if you have Section 8 housing vouchers or rural housing services, you may have certain occupancy limits. But generally for the private market, you want to look at any occupancy standards set by your local municipality. And if they don't, there are some other laws that you can look at. It's the International Property Maintenance Code, and we have resources on occupancy and how to calculate that. So it's based on square footage. That is the general assumption if there are no other regulations that you have to abide by. It is based on square footage, and we do have a calculator that you can utilizes one of the earlier property maintenance codes. So you just have to verify that those numbers match what you're looking for. And then we have a fact sheet and a guidebook. So one kind of gives you the rundown, one kind of walks you step by step, the guidebook of how to calculate that, and then also provides some examples of what that looks like. So again, you can reasonably limit based on square footage. Previously, we've seen a lot of, 2 heartbeats per bedroom, 2 heads per bed type language. This is an kind of older limits that were because homes were built very similarly. Now, because homes are built very differently and square footage varies really based on unit by unit, it's really best to look at the square footage of the unit and then determine based on that. And it is also best to keep those limits out of advertising. You really should just state that it's a 2-bedroom apartment or a 3-bed single family home. And then if a, 7-person family or, family tries to apply, you could say, based on occupancy standards, this unit only allows for, 5 people, say, but do not put those limits in advertising. Additionally, we have seen cases where different rates are being offered based on the number of people who occupy the housing. This is a violation. Some things we've seen is $1,000 per month for 2 people, but then $50 more for each additional person. This is discriminatory against, families with children, sometimes with marital status. So it should be a set price for maybe rent, and regardless of amount of people that live there, having those additional increments for people is a violation. Religion is also protected, and it is protected at the local, state, and federal law, and it's whether or not someone is a member of a particular religion or none at all. There are there's a narrow exemption for religious organizations that are limiting the sale, rental, or occupancy to members of their own religion as long as it is not operated for a commercial purpose. So it's not being put on the market, and it's only being utilized for the people within the religious organization for their members, and it's not, it's not being rentable for anyone. So that's the only really narrow exemption. And it's also really important for advertising to state, this home does not discriminate on the basis of race, color, religion, national origin, sex, and disability, or familial status. Some other things that we get questions on under religion, as long as symbols or terms relating to religious holidays are secularized, they're not automatically a constitute to violate fair housing laws, but it is something to be thinking about. And we often say err on the side of caution, of just not removing anything that is really, connected to a religious holiday. You may want, if you're doing like a happy Easter newsletter, just say happy spring, because it could create that people don't feel welcome in the community. And it may, oops, sorry about that. It may, constitute somebody not wanting to live there. Again, if there's a statement using the legal name of an establishment that contains a religious reference or symbol, it may violate the law unless there's a discriminatory or disclaimer that you do not discriminate. So it is thinking about maybe if your name has like Christian living, it would be really important to put that you do not discriminate based on the basis of any of the protected classes, as the statement I had that was in the previous slide. It is permissible, however, to say if there are certain facilities or services that are available, such as, you have a senior housing complex with kosher meals available, or there's a chapel there. Those are amenities, and you can promote that you have those things. And then looking at age, this is prohibited under state and local fair housing laws. It is not protected on the federal level, just the state level and the local level. It refers to someone's biological age, and as long as a person can legally enter into a contract, it cannot be used as a basis for discrimination. The only exemption for this is senior housing, so that 55 and older or 62 and older. That is the only exemption from age and familial status protections that are allowed. Some minors can enter into a contract. These are kind of the circumstances in which a person under the age of 18 may be able to enter into a rental contract. So if they're legally married, if they're on active duty in the armed forces, those are different examples where somebody may be able to enter into a legal contract. Examples of illegal age discrimination, these are often ones we see. It's a condo association limiting buyers or occupants based on age. So no one under 40 years old is allowed to live in this condo association. That is a fair housing no-no. Or we see fair apartment complexes steering different groups to different to different buildings. This is the under 14 age building. That would be also a no-no. So the only age limits are 62 and older and 55 and older, and that is if you are operating under those senior housing facilities. Here we go, transitioning into that. So it's under HOPA. And so the 62 and older is if it's occupied solely by 100% of people who are 62 and older, or if one person who is 55 and older is in at least 80% of the units, and they adhere by a policy that intends to house people who are 55 and older. We do have a fair housing for seniors guide for Kent County, which is also linked there. But that is the only thing that's considered senior housing, 62 and older and 55 and older. Any other age restrictions are illegal based on fair housing law. There are some limited protections for students. You must check your local fair housing laws first. If it's not protected, it may not violate fair housing laws to give a preference to students as long as it applies to all students, not those that are traditional student age. So if you are doing discounts for students or prohibiting students, it would have to be across the board and ensure that there's no local protections for students. But if there is a student that is a non-traditional student who may be over that 20 years age bracket, you still have to give them the discount or things like that. Moving into sexual orientation and gender identity. Sexual orientation is about who you're attracted to and want to have relationships with. Gender identity isn't about who you're attracted to, but who you are and how you identify. This also includes the perception of someone's sexual orientation and gender identity, as I talked about earlier. And this is covered under the Fair Housing Act, HUD's Equal Access Rule, and newly Michigan's Elliott-Larsen Civil Rights Act, and many other communities have these protections. So you cannot discriminate against someone because they are in a same-sex relationship or if they have an identity that you are perceiving them differently as. Source of income is protected in different local cities. So definitely check the locality in which you're living in to see if that is protected. For our local people, Holland, Grand Rapids, Kentwood, and Wyoming have these protections. In general, it's anyone that is receiving any legal verifiable income that should be counted towards their income, the 3 times the rent, things like that. And that can include Section 8 vouchers, child support, Social Security, things like that.
And I don't remember, Bree, if we talked about some pending legislation for source of income protections. This is something we've been keeping an eye on for more than a year, I'd have to say, because there's been a package of bills trying to address a statewide protection for source of income. They have passed the House and the Senate. The bills are all tie-barred and they need to be brought into agreement before they head to the governor. So this is something we've been keeping an eye on, but essentially it would create another statewide protected class where it would be illegal to discriminate based on where someone's money is coming from. It does include, some potential requirements that we may see depending on which final law comes into play and if it gets signed. But it's come the furthest that I've ever seen in all the years I've been working in fair housing. It would exempt small landlords, 5 or fewer properties, the way it's currently written. It would require housing agencies that have vouchers to move things along within a 30-day window of time. So this is also kind of a hot topic here in Michigan. So something to keep an eye out for and make sure you sign up for, follow us on Facebook or sign up for our e-newsletter, as we will certainly share out information if this legislation moves forward. It's passed through some significant steps being approved by the House and the Senate. So stay tuned, I guess.
Yeah, thank you, Liz. I wasn't sure if that was mentioned earlier either.
I don't remember, so I wanted to make sure to mention it now.
Okay, after going through all of those protected classes, we'll now look at some best practices. But really the most important thing is have policies in place and apply it to everyone. Best practice number 1, know your responsibilities under fair housing law. You're doing it right now, which is really great. But also look at other fair housing laws that may apply depending on where you operate. There's the Federal Fair Housing Act. In Michigan, there's the Elliott-Larsen Civil Rights Act, but is there also additional local ordinances that may have additional protected classes that apply? Establish application criteria, policies, and procedures to follow in accordance to law. Excuse me. Do any of these rules discriminate against anyone because of a protected class? Are there policies or procedures applied differently to persons that fall within a protected class? So these are some things to be thinking about when establishing any policies or procedures. Look at Train management, maintenance, and other staff on your policies and your commitment to fair housing. Have good risk management strategies. And fair housing training is a good one. If everyone who interacts with potential applicants or residents are aware of their fair housing responsibilities and your policies, ensure that everyone is educated on those things. So I'm really happy that we've had a lot of people on here today getting this information. Another one checked.
And just a plug too that we'll be doing 201 classes and 301 as part of a 3-part series for the winter. We'll have a follow-up summer series starting in June. Same classes, so you don't need to repeat them if you do the first series here in the winter, but the summer series will be 101, 201, and 301 as well. So we encourage you to check out our website, and I'll put the training page link in there. I also plugged one of our MSHDA funded classes. Again, MSHDA's hosting all of these, which is just really tremendous. Through a grant that we have with them, we're doing a deep dive for senior housing providers in May. So we're excited to be able to offer that as well.
Thanks, Liz. Oh, did I? Apply the application criteria, policies, and procedures evenly and consistently. Are you consistent with information about all the vacancies, waiting list, qualifications, all of the things that may be included in somebody applying, and if there's any policies, rebates, specials, are you ensuring that you're offering all that information consistently across the board and to every applicant who is coming into your office or calling? Make sure all tenants and applicants, as well as staff, are equally aware of the application criteria policies. Consistency is really the key here, and then also making sure you document everything. So again, just reiterating that you want to treat everyone equally, offer them the same thing, but ensuring that everyone also knows about all of the different things as well. All of your leasing staff, all of your even your maintenance staff, because it could be somebody just walking in and asking a question, or making sure that they know to point them in the right direction and who to ask. Ensure housing choice. Make sure that you're not making the choice about the unit or property that may meet someone's needs, but rather, offer those choices to people and then allow them to choose what best fits their needs. So another one that I gave the families with children example, but with people with disabilities, they may say that they're a person with a disability, so you may not give them any units with any properties with stairs because you're assuming that they cannot utilize them. Whether or not you know that or not, you removing that choice from them is against fair housing law. So just give them their choices and then they can make that decision for themselves.
Yeah, and if they identified, don't show me any units with stairs, then that they have chosen to opt out of those choices that they have. So
and document
it's a small difference, like you said, Bree, but it's really critical to upholding fair housing choice. They need to make the decision based on what options are available.
Consider requests for reasonable accommodations and modification based upon a disability on a case-by-case basis, and refer to the different resources that we have provided. We kind of went into this one pretty deeply, but just make sure you're considering all of those requests. Be familiar with local occupancy standards that apply to each property. Again, it should be based on square footage and but you should know, if each unit has a difference, you should know that the number of people that can fit in that unit. And then occupancy policy should not be more restrictive than local standards. Are you following local health and safety standards? And then there also is our own resources, but HUD also has an occupancy memo that you can look at called the Keating memo.
One example comes to mind for that, Bree, is a 6-bedroom home that was advertised for no more than 4 people. And that's, certainly a very low occupancy standard. The person was trying to point to an ordinance in a different city, not the city where the home was located, about the number of unrelated individuals who can live together. And it was all kinds of, I think, confusion and just wrong. So setting a number lower than the home can actually hold has a huge disparate impact on families with children. So it's important to prioritize doing this work on the front end. So this is another little bit of homework we're assigning you if you haven't looked at setting occupancy standards in compliance with local code. We really recommend that as a very proactive way to comply with fair housing.
Ensure that the property and its amenities are all fully accessible for individuals with disabilities. Fair Housing Accessibility First has some information on design and construction requirements that you can refer to. Review advertising materials for fair housing implications before publishing or posting. A big one, describe the property, not the people. Don't say that this is ideal for, ideal for couples, ideal for single people, things like that, ideal for active seniors. It's really not important. It's not good business practice to do so, and it's against, can be a big fair housing red flag to describe people. So just describe the property, say you have, a luscious park nearby, things like that.
Granite countertops,
Yeah.
rain shower head in the shower. I don't know, whatever the people are looking for, those are things you can advertise. And because we had some questions about HOPA and the senior communities, if you are working at a senior community that is 55 and older, or 62 and older, those are the only two age restrictions. You can post that in the ad that it's 62 and older and 55 and older, but that's it. You don't want to go into any other detail of saying, no kids or things like that. So.
Thank you, Liz.
Mm-hmm.
Advertising under fair housing is broadly defined and includes promotional materials, newspaper, internet advertisement, but also verbal statements. It is that's why it's really important that everybody has all of the information for units and is being consistent about providing that outward. And there is also linked here is HUD's Achtenberg memo, kind of looking at advertising. And if you have any questions, definitely feel free to contact us. Now we're going to look at some, applying some of these laws, addressing specific situations, armed with the knowledge that you have today. And again, so we're going to go through some scenarios and you can kind of pick how best you would respond to that. And again, have the policies in place and apply them to everyone. So I'm going to launch them. Again, these are anonymous. Okay. For the first one here, we have a 65-year-old male who has rented from you for 5 years, just began using a wheelchair. He's asking you to make a reasonable accommodation for his disability by paying for a ramp so he can have easier access to his first floor unit. What is your response to this? It is a modification, not an accommodation. We have to see if a ramp will fit in the space out front. He should use the door off the back deck instead. How we are funded impacts who pays. This is not reasonable. I need a letter from a doctor stating that he has a disability and disability-related need. This should be multiple answers. I apologize if it is not, but feel free if it says multiple choice, so you should be able to pick more than one.
Those fun Zoom settings that keep changing on us, but I am seeing people select multiple options, I think. So hopefully that's the case.
The second one here, a resident who uses a rollator works with you to have ramps installed at her door in the common area where other residents and visitors use. She has requested that you maintain both ramps. What is your response? She needs to maintain both ramps herself. We will maintain both of the ramps and charge her a fee to do so. She needs to maintain the ramp at her door and we will maintain the one at the common area. And neither ramp needs to be maintained. So I'll give a few minutes here. If you are in a group, you'll have to come to a consensus, but I will give you about another minute. I'll give folks 30 seconds or so here, just watching the numbers move up. So don't feel too rushed if you're having good discussion about it.
Yeah, we've got four more scenarios to go through, so we'll spend a little more time on these. And it looks like the questions disappeared on them, so sometimes they get minimized down on your taskbar, or you might have accidentally closed out of the poll, in which case we'll verbally review the answers as well. Sorry about that.
Yeah, again, these are done anonymously, and it does not is not a grade.
Not for credit or grading, yeah. We don't have that kind of authority. We're just nonprofit program folks. I think people get confused sometimes with the credits that real estate agents get, but there are no credits for rental professionals at this time. So we appreciate you all being here.
Okay, I think the numbers have slowed. So get your answers in. Give you about 10 seconds here so we can review the answers.
Oh, we're getting a mad flurry of responses.
Sorry, we'll wait it.
They were debating their choices. We have some good choices here. That's why we did it multiple choice. That's good. Great participation. We like to see it, especially for such a big class.
Yeah. All right. I will end the poll now. If you didn't get your answer in, that's okay. You have it in your head. So for the first one here, this was, sorry, I'm going to make this a little bigger so I can look at the answers. So for that first one, it is 43% of you were correct. It is a modification, not an accommodation. It is really important to ensure that if the ramp will fit out front, so that is a good step to take. And then people that said that how we are funded impacts who pays. That is another good step to take. And that's kind of some of those steps there. Those who said that he should use the door off the back deck instead, not a great response. And then he is a person who just began using a wheelchair, so having a letter from the doctor is not really necessary.
This is actually based off of a real advocacy situation that we had, I think, before you joined the team, Bree, and the staff knew that he was using a wheelchair because they had seen him using it. So having a letter from a doctor to verify what they already knew was an unnecessary step. And they did offer the back deck, but he would have had to traverse over grassy areas, which isn't safe. There was no paved access to that back door. So, and I do want to say, I've also worked with, there was a nonprofit housing provider who was really wanting to provide a ramp for one of their residences, but the house was built very close to the public city sidewalk, and a ramp would be too steep to put there. So, and they just felt awful saying, it feels terrible to say, no, we can't put a ramp to that front door, but it would have been in violation of city code and not safe. So then we looked at the side door and back door as possibilities of what could be built there. And in the end, the back door and the layout of the land on the back of the house did allow for a safe ramp that worked for the individual with the disability. But had it not, then they would have had to relocate that family simply because it wouldn't have been safe. So all these unique facts really do matter.
Yeah. Thanks, Liz. And then for the second one, a resident with the rollator, you were asked to maintain both ramps. Really the best course of action would be she needs to maintain the ramp at her door, and we will maintain the one to the common area. That is
and definitely no fees.
Yeah, no fees. And 68% of you chose that answer. So good job.
And ramp maintenance is always a good idea, especially if it's outdoor. We live in Michigan. We're under another weather advisory. Want to make sure that anything like that is cleared, just like sidewalks would be cleared.
Yeah, let me go to the next slide. Okay. 3 and 4. Several weeks ago, maintenance orders were submitted by 3 Latinx tenants. You notice that more recent orders submitted by white tenants were addressed instead. The repair orders for the Latinx tenants appear to have been ignored. What would you do? Talk to the staff to learn more. provide training about equal treatment. It depends on the types of repairs. There is no fair housing risk here. And then the second one, you just got an application for a vacant unit from a Black couple with one child. After they leave, the white man who lives next door stops in to ask if he can lease the unit for his son, as he doesn't want you to rent it to someone who isn't white. The Take the application from his son, process the family's application because your policy is first come, first serve. Document everything that was said, take the son's application ahead of the family, or call the Fair Housing Center. Those are your options. Again, multiple choice for both of them. And we'll give you a few minutes here as well. We have about 30 seconds or so for people to respond. I've seen it slow down, but if you haven't responded, please get your answers in. Okay. All right. Looking at that first one with the repair orders, it is a good process to talk to the staff to learn more because it could be that it depended on the type of repairs. So those are both good processes. And then I would think it would still be important to ensure that you're providing training about equal treatment as well. So good job. Those were the three most ones chose. No one chose. There's no fair housing risk there. So I'm glad that it's always important to be curious about why things may have been differently done and to just evaluate that. With the application question, you could take the application from his son. That is not, if he wants to apply for his son, he can. But the best answer is to process the family's application based on your policy, which is first come, first serve. And then also document everything that was said. You can call us as well just to make us aware of it. If there anything came about of it, you could definitely call our office, let us know, or talk to us about the situation as well.
We can help educate that neighbors cannot intervene with someone else's housing choice. It's just not prohibited by Fair Housing Act regulations. They also cannot harass other residents or interfere with somebody's ability to kind of stay where they are. If they're interfering with somebody's ability to access housing, or if they're harassing them to the point of getting them out of the housing, those are violations under HUD guidance for harassment too. And unfortunately, that's on the rise. So we do have a new fact sheet about that on our website.
Thanks, Liz.
Mhm.
All right, we're going to move on to the next two. 5 and 6. A family of 4 lives on the property in a 2-bedroom unit. They recently had a baby, their 3rd child. The unit is 949 square feet and holds 4 people according to local code. Their lease is not up soon. What is your response? Begin paperwork to make them move out. If they do not ask for a larger unit, they should not be forced to relocate. It is usually reasonable, to give the family at least through the end of their lease and even up to the child's 2nd birthday to vacate the premises. Consult local ordinances, look at the guidebook, fact sheet, things like that. 6, you are reviewing an application from a young couple with 2 children. They appear to be qualified, but you notice that the wife has a felony conviction and just spent the last 3 years in a state prison. What is your response? Automatically deny them, or it depends on what the property's policy is. The answer is slowing down, so give again 30 seconds or so to get those answers in. Okay, I'm gonna end the poll and share the results there. Um, so there's a few different options for this, but I would say the best answer is to usually it's reasonable to give the family at least through the end of their lease and up till this child's second birthday to vacate the premises. But also it would be important to consult local ordinances and things like that to verify that that is the information. Um, that is giving up until the second birthday or through the end of their lease is kind of some case law that we have seen. And then reviewing the application with the felony conviction, it depends on the property's policy. Automatic denials for felonies, blanket bans are highly frowned upon and are a fair housing risk because, as Liz talked about, it really depends on the word is escaping me, but the type of the crime. If it was a harm to people's
Nature,
property,
severity,
yeah,
yeah,
the
and
nature, the
how long
severity,
ago. Yeah,
yeah,
those are kind of the 3 points that have been upheld.
yeah,
If you are screening, you look at the nature, the severity, and how long ago.
yeah. So, yeah, so again, it depends on the property's policy and just looking further into the conviction. And sorry. So yeah, that is it for our scenarios. So we're gonna wrap it up here with a few more points. Thinking about discounts and perks. When is it okay to offer specials? Kind of look at fair housing laws and kind of evaluate that. It is illegal to charge higher costs for people based on race, so an African American couple compared to a white couple, and it is illegal to charge families with children higher costs. So kind of look at your discounts and perks and who does it affect negatively, and does it show preferential treatment to certain protected classes? One thing that we want to share, housing testing is something that we do to monitor the market to see if there is differential treatment happening, and it is a scientific measure of distance. It's about the quality of the information, the content of the information, and quantity of information. So what type of information are you giving applicants or tenants, and how much? It looks at the availability, the price, terms and condition, any information exchange, any of the treatment. It could be, if you were very cold with somebody versus if you were smiley with the next. So it's really important to be consistent because this is what testing is looking at. They're looking at the various terms for somebody that is looking for housing. There are some safeguards in place that we do want to be clear about. So there is a separation of roles between enforcement staff and testers. Testers receive training. They conduct practice tests and they have a follow-up training as well. They are objective rather than subjective. There are standard forms. There's a narrative to be had. So it's not based on subjectiveness. It's exactly what happened. There is no contact between testers. Testers don't know about other testers. They're not meeting up together. And they don't know that what they're being tested for. And they don't know that another person is being tested at that, for the same properties. There's a lot of there's a lot of safeguards in place. And we also do side-by-side comparisons to show if there's a difference in treatment, which we'll look at.
Before we look at that side by side, I just want to clarify, we usually will send out a pair of people based on the protected class. So if we suspect that disability-based discrimination is occurring or discrimination based on familial status is reported to us, we send out paired volunteers. For example, in my first one, it'd be a person with a visible disability, and then the comparison person would be someone without a visible disability. If we're told, I was turned away because I have young kids, we would send out a volunteer without children, but the same number of people in the household. For example, myself and my two older parents were a household of three, would be compared to a single parent with two young kids. And it's literally, as we'll look, a side-by-side comparison, and it's about that treatment, like Bree said, of were they taken seriously, were they welcome, were they given accurate information? What's the overall message and what's their overall experience? Were they taken seriously as a potential applicant and resident?
So yeah, looking at an example test here, we have two testers, an African American tester and a Caucasian or white tester, and they both met with the same agent. There was a slight difference in the time with the agent, but that really wasn't anything to draw to. But then looking at the availability, the black tester was given the only option of a 1-bedroom, where the white tester was given two options of two bedrooms. So that is a significant difference. If the black tester was told that there was a wait list, the white tester was not given any information about a wait list. Rental rates were also different. But the security deposit was the same, application fee was the same. And then we see here at the checks, the black tester was told that there was a background check and an income check, where the white tester was only told about the credit check. The white tester was also told about specials and told about other cool amenities, where the black tester was not. So through this test, you can see there's significant differences of treatment throughout the whole test itself and the whole process. So the Fair Housing logo is available online, and this indicates that to the public that the property is available to everyone under the Fair Housing Act. There are specific requirements for size and location and when it'll be used, but that can be all found on that link through HUD's website. These posters are also no longer available through HUD, but we can provide them, but these should be posted in public spaces to show that you are compliant with fair housing law. We have these in both English and Spanish, so feel free to contact us if you need them. And then as this training is funded through MSHDA and is for MSHDA funded properties, here are some more additional resources and links for those properties and to utilize. And that wraps us up. So if you have any questions,
we do have a couple questions.
Please feel free to put those in the chat. Additionally,
Q&A would be better, actually. Yeah.
Yeah. Oh, yeah. Sorry. Q&A.
There's a small difference between the two.
Yes. But we will be putting, what I meant to say was the link in the chat for the evaluation. Again, every person attending must complete this by 5 p.m. tomorrow. Otherwise, we cannot guarantee a certificate. So please do that now. We will post it in the chat, but it also will should have been opened up in your browser. And then certificates are provided to those who utilize that link to get those. And then just another reminder, we have the 201 and 301 continuation of this series for those who are interested in attending.
Yep, and I put the training webpage link in the chat, so you can find these trainings and all, I think we have 8 others open for registration and scheduled right now. So grab that link. And then a question on income. There's a question about IFFC, Salvation Army, and the 3- and 6-month programs they carry. I need a little more information about those programs, but generally it sounds like you have potential applicants with short-term income. It's legal and verifiable income, so it should be counted as such, but I understand, if you have 3 months of income and you offer a 12-month lease, what do you do? I think that's something that is being considered by the source of income law, and so you'll want to pay attention to that. We would also want to look at any local source of income protections based on where you're operating. and maybe give us a little bit more information. If you offer shorter leases, that may be a solution. If you don't offer shorter leases, then we want to assess fair housing risk and saying no to something like that. A question about rural development properties. I was told we do low income, but we don't do no income. How long can a current resident reside with no income? If somebody isn't paying rent and it's not related to an accommodation or disability-based need, that likely will default to tenant landlord law. So that's something that, generally I can answer, but if you have more specific questions, please do feel free to reach out with that. A question on reasonable accommodation transfers. Are we able to follow written transfer policies such as new rental amount being charged and follow waitlist policies? That is a great question. I do think we'd want more information there. A reasonable accommodation request, especially for federally funded properties for a transfer, I think can take precedent. And so we need to know a little bit more what's in those policies before we can say, yes, that's something you would want to default to. So great question there. Public apartments for a person with mental health issues on disability, if they're dangerous, does this person receive considerations versus the other tenant's safety? So I recommend that you check out the HUD DOJ joint statement on reasonable accommodations, which has a whole section on what they consider direct threat and how to handle incidences where somebody may have disability related behaviors tied to violence, and whether or not those behaviors can be brought under control if they seek treatment and things like that. So that's kind of the direct threat assessment, and that's something I would encourage you to review and then circle back with you have questions. But it is about striking that balance between maintaining safety for everyone on the property and staff, and then accommodating based on a disability. So very good question. A couple of really good questions that we're going through quickly, I know.
Thank you so much, guys, for attending and being here and asking your questions. Again, if you want the posters, please email us so we can get those to you. We may not.
We need your mailing address.
Yeah, because we need your mailing address. Yeah, please let us know and send us an email. And then if you have any additional questions after this class, feel free to reach out to us via email for if anything comes up as you're pondering on this later. Otherwise, we'll stay on for a few more minutes to answer any additional questions. But if you do not have any, feel free to log off and have a wonderful day.